I believe that distinction must be drawn between the factum probandum and the factum probans.
That's correct. Yes. What is the probandum here?
The probandum here, Your Honor, is as stated in Article 2 and in the body of Article 2 explaining it, since the title cannot be taken in isolation, it is failure to report SALN or disclose SALN to the public and the commission of the acts described in paragraphs 2.2 and 2.3. As a matter of fact, even with respect to Article 2.4, if I may be permitted to respectfully invite attention to the journal record of January 25, 2012, starting on page 3, where we see the name Senator Drilon, just to amplify Mr. Senate President, when the court ruled indeed that the court will allow introduction of evidence on 2.2 and 2.3, which would allow evidence to prove that evidence can be introduced that a property, whether real or personal, is not included in the SALN. However, under Article 2.4, which asserts that such properties could be ill-gotten, the court did not rule on that, and we will rely on the presumptions of evidence, on the presumptions of law, particularly the anti-graft law, Mr. President. The presiding officer, that is correct. End of quote. It is our humble submission and manifestation then that this honorable court,
just a minute, Counsel.
Yes, Your Honor.
We are guided by a decision of the Supreme Court in the case of the impeachment, articles of impeachment against the former Ombudsman Merceditas Gutierrez. I'm trying to get a copy of the decision, and in that decision, the Supreme Court opinion penned by the present Ombudsman, then Justice Conchita Carpio Morales, said that the articles of impeachment must charge only one, must embrace only one charge for each articles of impeachment. That's very emphatic. It's a rule established by the court. We did not establish it here. So I'm sad to say that there was faulty in the crafting of your pleading. And that is why we had to correct it in a caucus. We became very liberal, in fact. And we allowed paragraph 2.3, but we disallowed paragraph 2.4 because it's obviously not germane to the question of SAL, to Article 2, and you included it in Article 2 of the Articles of Impeachment. And in fact, even paragraph 2.3, if you read the specification under the grounds of impeachment stated in your Articles of Impeachment, for Article 2, you merely allege the ultimate fact of non-disclosure of the SAL. But we became liberal to allow evidence to be introduced for on paragraph 2.3 of your discussion. Menu, this is the discussion of your Article 2. Not Article 2 itself, but a discussion of Article 2.
Mr. President, Mr. President, Mr. President.
The gentleman from Makati and Bicol.
I hate to say this, but the rule as directed by the chair and the body is that private prosecutors can conduct the examination of witnesses but cannot argue points of law and whatever. Then if we liberalize this, then we will have again another problem. I am now trying to stand up every time I see a relaxation of the not relaxation, but a violation of our rules. Otherwise, there will be no order here. That's all, because nobody is suppressing the prosecution from presenting their position, but it has to be a member. I was a member of the prosecution before, but it has to be the House, commissioned by the House of Representatives, that will have to articulate and represent the House of Representatives. But counsel, outside counsel, cannot, because they were not given the authority by the House of Representatives as the prosecutors. So
That is correct. That's under the rules of the House itself that created the panel. So I think the lead counsel of the House should exercise his power to control the private lawyers hired by the House to assist.
We'll do that, Your Honors.
Your Honor, please. In connection with the topic we are now discussing, Your Honor, may I be permitted and allowed to read the portion of the disposition as embodied in this journal, Your Honor, or minutes of the proceedings yesterday. It states, and I quote verbatimly, Your Honor, the prosecution may introduce, if it has, evidence that would support the allegations contained in paragraph 2.2 and paragraph 2.3 under Article 2 of the Articles of Impeachment, but not to introduce evidence under paragraph 2.4, Article 2 of the Articles of Impeachment.
That's correct.
This is the disposition, Your Honor.
Yes.
And we have not seen any modification, much less reversal of this particular disposition of this honorable court. Now, may I now proceed to the amendment which was posed by the honorable Defensor Santiago, Your
The
Honor.
gentleman from Iloilo, Senator Drilon.
Just to complete the reading of the records, on page 4 of the records of the Senate sitting as an impeachment court, Wednesday, January 25, 2012. After the Senate President issued an order that the prosecution may introduce, if he has, evidence that would support the allegations contained in paragraphs 2.2, 2.3 under Article 2 of the Articles of Impeachment, but not to introduce evidence on 2.4 of Article 2 of the Articles of Impeachment. So ordered. We stood up and clarified that the court ruling during the caucus was as we have stated on page 4 of the records. And we said, when the court ruled indeed that the court will allow introduction of evidence on 2.2 and 2.3, which would allow evidence to prove that evidence can be introduced that a property, whether real or personal, is not included in the SAL-N. However, under Article 2.4, which asserts that such properties could be ill-gotten, the court did not rule on that, and we rely on the presumption of evidence, on the presumption of law, particularly the anti-graft law, Mr. President. And the presiding officer said, that is correct. And that's clear on the records, Mr. President. And this is a reflection of the ruling of the court during the caucus, which was manifested by the President and this representation in open hearing, during the actual hearing. So I think the records are clear, Your Honor.
We have no, Mr. President, we have no quarrel with the observation made, Your Honor, but what we wanted to place on record is what was dictated orally as the resolution on our motion, Your Honor. And this is not part of the resolution. This is merely a narration of what happened in that caucus. It does not form part of the decision, Your Honor.